my name is Kristin Bays. I am running for County Court of Law number 2. I realize you just heard that, but some of you just walked in. So I wanted to make sure that you knew why I was here. I will tell you that I applaud your efforts to look for conservative candidates for all of the offices for which people seek election, because conservatism is truly the best way to run a government. And the government that governs least governs best. And I will tell you that a healthy skepticism of judges and judicial candidates really does have a tradition in American history. Because make no mistake about it, we need courts, we need judges. They provide a governmental function that is just inherent. It can't be served by private enterprise. And in fact, it was Thomas Jefferson who remarked that the most sacred of duties of a government is to do equal and impartial justice to all citizens. That's what courts do. Courts provide citizens with a place to resolve their disputes in a fair and orderly fashion. But it was also Thomas Jefferson who just 5 years later wrote to a judge that his greatest fear was the federal judiciary. What he was talking about is that he was noticing that judges tended to take sort of quiet little steps forward, usurping power along the way. His concern was that if that snowball effect continued, judges would deem themselves to be legislators, and the system would break down. It's almost as if he predicted Roe v. Wade. So how do you accomplish having a judge who fulfills the most sacred duties of government without using it as an opportunity to promote a personal agenda for judicial activism? You elect a Scalia. You want to elect someone who will adhere to the rule of law, someone who understands, as a strict constructionist, that the rule of law is written down. If it is not written in the Constitution, if it is not written in a constitutional statute, it is not the law, and a judge cannot make it so just because she wants to. I'm your Scalia. Those are principles that I firmly believe in, and I always have. Now, how do you know that I'm telling you the truth? Because I'm a legal scholar. I will tell you that that's what I've always loved. I love the principle of having the rule of law as a foundation for our government, that your rights are not contingent on which judge you might draw and have your case heard in front of, that the rules are written down. Citizens know what to expect. They know what is expected of them. These are principles that took me to law school. I went to law school on a full tuition scholarship because of my judicial scholarship. I went to law school and was the editor-in-chief of Law Review. I was on moot court and mock trial teams because of my legal scholarship. Even with all my extracurricular activities, I graduated 5th in my class because of my legal scholarship, and I didn't stop after law school. My career has really been focused on researching legal issues, looking for where it's written down, applying it to facts, and sometimes I have to tell my clients, it's a no-go. That's what you want in a judge. You want someone who looks for the law, and if it isn't there, it's not there. That's what the rule of law means. That's the kind of judge that you want. That's what ensures stability in our society. But what you need to know is that this particular court, County Court 2, is a specialized court. Under the rules of the Texas Supreme Court, this court is a civil trial court. It doesn't hear any criminal cases. It only hears probate cases and civil litigation cases. So if you want a judge who will adhere to the rule of law, you need to have a judge who knows the rule of law. You need to have someone who is experienced in those areas of law, and that's me. I've been a lawyer for 16 plus years, and my practice has been in probate and civil litigation. I know it. I know the codes that are applicable. I know the constitutional principles that are applicable. I know these areas of the law. That's important to you. You need a Scalia. You need someone who is a conservative, judicial person. You need someone who understands what the rule of law is and adheres to it. You need a Scalia. You need me. I am asking for your support. I would love to have your endorsement, and I would love to answer any questions that you might have of me this evening. I know there will be many.
We have to do one more time.
I suspected that you did.
Okay.
I'll start out.
Okay.
Do you have a family?
I do.
Could you tell us a little bit?
Yes, I'm married to Randy Bays. That's my husband. We actually have a law firm together. We practice in Conroe and have our own firm. We've got 3 kids. One of them is really his. He's my stepson, but I helped to raise him. My husband had custody of him, and I helped to raise him, send him to UT, the whole 9 yards. His name is Doug. He's 26 years old. He is a nuclear engineer. Don't ask me what he does all day. I have no idea what his job is. But we have 2 young kids together. I have a son who just turned 12. I have a daughter who is 8.
Okay. Next question. Any question?
I do.
She's been one of my most reliable.
You said that this court is not a criminal court, but could you technically be called into a criminal case?
It is theoretically possible, but practically it just really wouldn't happen. And I'll tell you why. Back in 2005, our county court of law judges, we have 5, at that time we had 4, but we now have 5, they made the decision that the best way to move the cases was for the courts to become specialized. All those courts have the same jurisdiction over the same types of cases, but cases were getting bogged down. The judges were being called upon to decide cases in areas of the law that they just didn't have the familiarity with, particularly in probate. That's kind of the black sheep of the list of cases the county court of law judges hear. So they decided to try specialization, and that's when County Court 2 became the only one of our courts that does probate and civil litigation. The experiment worked. It worked so successfully that all the judges, all 5 of them, plus our 7 district court judges, petitioned the Supreme Court to make that into a local rule. And the Supreme Court did so on a 9-0 decision by the court. So could it change? Yes. If the County Court of Law judges made a decision that County Court 2 should be hearing criminal cases, yeah, it could change. But remember, their votes are already cast. They came in April of 2009 when they petitioned the Supreme Court, and their votes are County Court 2 needs to be the civil litigation and probate court. So I don't see a change as being likely. It's certainly not one on the horizon. And bear in mind, no single judge can make that decision. That is something that would have to be made collectively and ultimately approved by the Supreme Court. I think the die is cast. This court is the probate court. It is the civil litigation court. It wouldn't hear anything else.
Edwin, did you have one?
Yes.
Okay.
Yes. One of the arguments against the healthcare bill currently is that healthcare is not a right because you have to enslave one group of people to pay for the healthcare of the others. Mm-hmm. It cannot be a right. However, the Constitution provides for due process and the right to counsel, competent counsel. When it comes to indigent, I almost said indigent care, but legal, what do you call it? Legal help.
Legal representation. Legal
representation for the indigent. How far should the courts go in providing that in terms of cost? And the other kind of side issue to that is one time a judge in Walker County refused to let me defend myself in her court. And so she forced me to fill out an indigent care thing. So she decided she was going to appoint an attorney and forced me to fill out this indigent care thing. Would you refuse someone in your court to defend themselves?
No.
Okay.
No, absolutely not. I mean, you certainly have the right to counsel in criminal cases, but you also have the right to defend yourself, to represent yourself in court. I really sort of staggered to hear that there would be a judge who would deny you that opportunity.
Mason Martin used to do it all the time.
Well, Mason, anyway.
I believe we have a question back
Well, she
here.
didn't answer
there was
my first part of my question about the cost.
There was one other thing that he'd asked about the cost related to indigent representation. And I will tell you that my answer is twofold. Number one, really that right only exists in the context of criminal cases, and again, this court really doesn't do criminal law, so it wouldn't really come up in this court. But the second issue is this. There are probate cases where counsel gets appointed. It is a rare thing that you don't have an estate that is sufficient and solvent to be able to pay for that itself. The court does look to that to see that the county and the taxpayers are not charged with that. On the occasion that you have a truly indigent guardianship, for example, I mean, I've seen that with young children who don't have any property of their own, the county would step in and pay counsel about $300. That's the norm. But how often does it happen? Not often at all. And I will tell you that you should be proud of the attorneys in this community who serve as ad litems in probate cases, because they tend to waive their fees in cases like that. So the taxpayer doesn't pay, nor does the ward of the guardianship.
Y'all will be going in child custody cases?
No. This court would not hear any family cases involving child custody issues.
Thank you.
Question.
Go ahead. Let's go over here to you, Don.
You actually were pretty forthright in your answer of 15 of Roe versus Wade should be overturned. You said that you said yes. I was just curious. You didn't feel like that would inflict any kind of pain on your judicial integrity? Since this is not a court that would vote on this per se,
Right.
you didn't feel like it would compromise you in any way?
Well, I will tell you, I did have that concern, but let me tell you what I did. I read the Republican Party of Minnesota versus White. That's a U.S. Supreme Court opinion from 2001 or 2002. I think you must know it. You're nodding vigorously. And what the court said is that under the First Amendment, judicial candidates cannot be so restricted